Hello and a very warm welcome to yet another interesting edition of the program CAC Weekly, a weekly program that keeps you abreast on the activities and the achievements of the Corporate Affairs Commission. My name is Amina Jabril, and now coming up, annual general meeting comes on the focus. CAC branch of Senior Staff Association of Statutory Corporations and government-owned companies takes a giant step to ensure industrial harmony. But we'll be right back after this break. Do stay with us. And now welcome back. The Senior Staff Association of Statutory Corporations and Government-Owned Companies, Sascog, is one of the senior staff associations registered by the federal government following the restructuring bodies in 1978. Now, it was registered to cater for senior staff of public organizations at federal and state levels outside the core civil service and the oil and banking services sectors. The founding members of the association include the Electricity Corporation of Nigeria, later the National Electric Power Authority, NEPA, and then the Power Holding Company of Nigeria, PHCN, the Nigerian Ports Authority, Post and Telegraph, later Nigerian Postal Service, NIPOST, and then Nigerian Telecommunications, NITEL, Nigerian Aviation Authority, later Federal Airports Authority of Nigeria, FAN, and then Nigerian Railway Corporation and Nigerian Broadcasting Corporation, later Federal Radio Corporation of Nigeria, FRCN, and then the Voice of Nigeria, VON, respectively. In the year 2020, the Corporate Affairs Commission became its newest member. Now, in a bid to ensure industrial harmony between the union and management in accordance with the mission of Sascog, the CAC branch of the union teamed up with the Dangote Business School, Bayero University, Kano, to stage a 5-day workshop on labor management relation in contemporary public service in Nigeria. No fewer than 18 Sascog members participated in the maiden workshop. Comrade Suleiman Giray, Sascog president of the CAC branch, bears his mind on the workshop and future plans, while other participants sum up their feelings.
We sincerely thank the management of the Commission by seeing it necessary for the union leaders to be trained on industrial relations so that there should be industrial harmony between the management and the labor union. And another thing that makes me so happy in this aspect is that most of the executive members who are on board this time, they are all newcomers. So the training will go a long way in enlightening them and giving them an insight on what labor-related matters are all about.
Yes, the takeout from here is to re-emphasize our core values, which are one, productivity, that our members in Corporate Affairs Commission will give their best and all to the organization in terms of hard work, and then to see the management as our social partners. We are not fighting. The mandate is the same. We want Corporate Affairs Commission to be the best, one of the best in the world, and to do that, we have to support, we have to collaborate, we have to cooperate, and most importantly, to bring ideas to the table where there are issues at the workplace. In these days, you don't go and close the offices and say you are going on strike just because there are issues. You first of all bring ideas to the table on how to solve the problems. And Sascog is known for that.
There is a basic thing which I have learned and I discovered that industrial action is not all about going on strike. It's about negotiation. And also, mostly the survival of the organization when issues are come to negotiate or when we have issues that we will bargain. The bargaining process is more than taking a quick industrial action, which may be the last resort, or to me, should not be at all, because the understanding is most effective than taking action which are voluntary to affect the organization and also the staff and the employees in general.
There is a lot of differences because this management is encompassing. They are trying to bridge the gap between management and the staff, and in fact the union and by the other side. In fact, based on what I see on ground, there is a lot of progress based on what we have seen right now.
I've learned about the working relationship in the office, how the management relates with staff, how also to make staff, to give them more, to be motivated, So like they have to give people responsibilities. You don't leave a staff redundant, like probably because you say, if this person cannot do it, let's just leave him. You're not helping the person. Because eventually the person will now be in a management position and now can't do anything. So I think we have to like engage our staff and motivate them also.
Also, Dr. Maazu M. Maazu of Dangote Business School and Hadiza Katagum Tanja, the Assistant Director, Head of Industrial Desks, CAC, spoke to CAC Weekly.
The take home from this training the change of attitude, change of mental model, and the way they perceive management, thinking about them will change, and people will be able to understand some of the frictions in industrial relations as regards management staff relationship in CAC, which we hoping that all this, if they are put together, would increase their performance in their various departments and units, which overall will transform Corporate Affairs Commission to greater height.
I must say I'm very impressed. The venue is excellent, facilities. This is the first time we're using Dangote Business School and we're very impressed, and the course content is okay. The lecturers are seasoned, and I must say it's a step in the right direction.
And now we move on to CAMA 2020, the game changer. In continuation of the focus on CAMA 2020 and some of the Commission's reform initiatives, today we shall take a look at the Annual General Meeting, AGM. Are small companies exempted from holding AGMs? Tolulokbe Adiola Sonaike, the Assistant Director, Registry Department, x-rays the concept of AGM in CAMA 2020. Do enjoy watching.
Thanks for joining us again.
Thank you.
All right. Today we're going to be looking at the review, the requirement review of the annual general meeting under the CAMA 2020. I know before now people say there have not been general meetings before now, but I think CAMA 2020, that's the Companies and Allied Matters Act 2020, make some kind of adjustment. Okay. So before we go into that, why is it so important or necessary to have, for companies to have annual general meetings?
Annual general meetings is a medium that provides for what you call accountability, reflections, and feedback interactions between the company and its many stakeholders. Now, there's this agency theory in company administration where it is believed that the board of directors who directly run and manage these companies are actually running it as agents for the owners. So you have, just like you have separation of powers in governance, so do you have in corporate matters. The owners come together and say, let us form a company. And then they say, okay, we have formed the company, but let us engage these persons to run the company for us. So then you have the directors. Directors can be hired and fired, right? So directors to have their own instruments, the arrangements for running, which are also board committees. Now, at the end of the year or financial year, every company has a financial year. It is important that you let your stakeholders, particularly the shareholders, the owners of the company, to know how you have performed during the year. So you find that at annual general meetings, you have things like the director's report, auditor's report, mainly reports. We want to know how you have done over the years, and so you report on several aspects of the company's administration.
And for those who are declaring profit and losses, they want to know how much dividends.
Yes, shareholders want to know how you have done it, and they can interrogate your report. They can ask questions.
Okay.
So annual general meeting provides that forum for you to interact with every stakeholder.
Okay, so it's a period for stock taking.
Something like that. Okay. Something like that. And to take further decisions on how you have the outlook for the next year.
Okay.
The directors make projections and tell you that, well, this is what we did in the past, and this is what we expect to do going forward. This is what we expect that the business climate will look like, and this is the performance you should expect from the company.
Okay.
So it's also an agenda setting forum.
Okay.
Right.
All right. Under the Company and Allied Matters Act of 1990, I'm sure everybody is supposed to hold an annual general meeting. But CAMA 2020 is saying there's some kind of exemption. Smaller companies are not allowed to hold annual general meeting. Why the exemption?
Right. But small companies and single shareholder companies are not obligated to hold AGMs.
Okay.
For small companies, we understand. I mean, they can do their meetings, right? But they don't have to say it must be an annual general meeting. Again, that does not mean they should not.
Okay.
It's an exemption. It means you don't have to do it, but they may choose to do it. Okay. But all other companies are expected to hold annual general meetings.
Okay.
And the first annual general meeting must be held within 18 months of the incorporation of the company.
18 months.
18 months. And then subsequently, every annual general meeting must be held within 15 months from the last one.
Okay.
So if we held the last one at a particular date, the next one, we must hold it before the expiration of 15 months from that particular date.
Okay. And I do understand that you're supposed to apply to the commission for notification if there's going to be an extension.
You can apply to the commission under the same section 237. You can apply to the commission for an extension of the time to hold it. Now, that application must be made before the expiration of the 15 months ordinarily provided for you to hold it.
Okay.
You shouldn't be applying after the expiration of the 15 months. If that happens, then you cannot come to the commission. Your recourse will probably be to the courts.
Okay. So now let's look at the businesses that are transacted at the annual general meetings.
Okay.
Under CAMA 2020. Yeah.
Now, under CAMA 2020, one other business has been added to what you describe
what
as...
were the businesses before?
Okay, what I'll describe those as the traditional businesses. I mean, you have every business transacted at annual general meetings are special businesses, right? Only a few are described as ordinary businesses. Now, it's the ordinary businesses I'm going to talk about. Nothing as for the special businesses can be anything, right? But the ordinary business of an AGM, that is what has been expanded to include one other item. Now, originally, traditionally, you have declaration of dividends. It's an ordinary business. You have a presentation of the report of the directors, of the report of the auditors and financial statements. That's another business. You have the election of directors in place of those retiring. That's one. You have the appointment and fixing of the remuneration of the auditors. You have the appointment of the members of the audit committee. And then the last one, which is the new addition, is the disclosure of the remuneration of managers.
Okay.
You know, the earnings of managers for the year. You know, people have asked the question that who is a manager? That's a very open one. Do you have to declare the remuneration of all the managers you have, particularly if it's a very big and large
That's
company?
like globalizing them.
But while the Act did not provide a definition of who a manager is, the Companies Regulation 2021, you look at Regulation 49, which is the interpretation regulation, has described who a manager is. So a manager is that person, by whatever name called. You may not even call him manager. You may call him coordinator. You may call him head of whatever. You know, so that officer who occupies a position in senior management and who is vested, who has some significant power, discretion or autonomy, authority, you know, in the administration and management of the company, whether in full or in parts. Right, so the easy example will be what you call like your regional managers. They are not your directors. Before this inclusion in the ordinary business of an annual general meeting, it is expected that your report, the director's report, will contain the financial statement, the earnings of directors.
Okay.
You know, that one will be there. But now these persons will also have enough power, they are vested with sufficient powers, you know, autonomy, to administer some parts of the company, take decisions on behalf of the company. Like regional managers, those who qualify under this one.
Okay.
And certain even branch managers who qualify under this one. You must disclose their earnings their remuneration for the year.
Okay.
That is what CAMA 2020 has added.
Okay, all right. But so let's go to the place of meeting. As far as the annual general meeting is concerned, we do understand that under Section 240, subsection 1 in CAMA 2020, the place for the annual general meeting must be in Nigeria.
Right.
And then private companies can hold their meetings electronically.
Very well.
But for those who hold electronically, can sit somewhere in London and have the virtual meeting and say they are in Nigeria.
Well, what the law requires is that you are right when you said Section 240, subsection 1, does require that the place of your annual general meeting should be in Nigeria, right? Except for small companies, again, a single shareholder company, if they decide to hold their meetings, they can hold it anywhere, right? But for all other companies, the place must be in Nigeria. Again, the law allows for private companies to hold virtual meetings, what you call electronic meetings, e-meetings, right? And then the concern will be, if I'm holding e-meetings, why do I need to talk about a venue? Because this is virtual, in the virtual space. Now, for the purpose of satisfying the requirement of Section 241 that says the place of business must be in Nigeria, what the regulation has done, the Commission has no regulation in that regard. What the regulation has done is to say, for your minutes, it is enough for you to indicate that that meeting was held at your registered office.
Okay.
Because the registered office of companies, registered under the Companies and Allied Matters Act, must be in Nigeria.
Okay.
You cannot register.
So if you take your meetings to a hotel or to somewhere, to a resort, it's not acceptable?
That is not a physical meeting.
Yes.
We are talking electronic meeting. Yeah, if it's a resort, if for physical meetings, if it's a resort in Nigeria, yes.
Okay.
Yes, but you cannot take it to a resort outside Nigeria.
Okay.
Yeah, it does not have to be held under, it does not have to be held in your registered office.
Okay.
Anywhere in Nigeria, you can hold your AGM there. Okay. Right. So for the purpose of satisfying the requirement of venue, even for e-meetings, you can state in your minutes, because you must have minutes, that the venue was a registered office or any other place, address in Nigeria, but the secretary and the director must be present there.
Okay. And again, for private companies, their articles of association must indicate that they
before you can hold
meetings before they have, otherwise they will be penalized.
It will even invalidate it.
Oh, okay.
Because your articles must permit you to do that.
Okay.
If your articles don't permit, because the Act is clear about that, that if your articles permit you, you can hold meetings. Your articles, your meetings must be conducted in the manner that your article prescribe. So that means your articles must contain that clause that says you can hold e-meetings, and must go on to provide for conditions for procedures to conduct. Must address things like speaking. How do you speak? How do you vote? Because people must be allowed to speak. How do people get access? And not be disqualified or disenfranchised.
Can't it be the same proceedings, the same meeting proceedings?
Yes. But it must be clear that everybody has an equal opportunity to talk.
Oh, okay.
And that when they want to vote, they can vote, and their votes can be seen and counted.
Okay.
So those things must be there. How do you expect to manage all of those things? And that they are audible, they are heard.
Okay.
The technology.
But some people's mic will go low. Some will be faint.
And then you want to be sure. You want to be sure that you don't mute people you don't want to hear. Don't forget that somebody's going to host it.
Yes.
So just to be sure that you have a level playing ground, the same playing ground that you have when we are in-person meetings.
The opposition voices are not suppressed. That's what it's all ended. So now let's go to the notice of the AGA and persons to be notified.
Right.
Section 243, subsection 1E, specify who are the persons to be notified here. So who are, maybe you have us.
Yeah, for general meetings or annual general meetings, generally, you need to, notice must be given to every member of the company, who is entitled to attend and to vote. They must get notice.
What is the duration of that notice? Is it like a week notice? Or
No. For annual general meetings, 21 days.
Okay.
21 days from the date it is posted.
Okay.
Then, in case of members that are bankrupt, or who suffer lunacy, they can have legal representatives. They can have receivers for bankrupt people and all of that. So their legal representatives for receivers must get notice. Then every director of the company must be notified. Every auditor for the time being must be notified. At each annual general meeting, you must appoint an auditor. Okay. So whoever is the auditor for that year must be notified that there's going to be an annual general meeting. The secretary, of course, is the one issuing the notice anyway, so he must notify himself, so to speak. And in the case of public companies, this also is an addition, a new one, under CAMA 2020. The commission, CAC, must be notified. Okay. In the case of public companies. Now, you're talking about the content of the notice. Yes. The notice must state the place, the date, and the time for the meeting. Okay. Right. And then the notice must also give sufficient details of the general nature of the business to be discussed at the meeting. Okay, like the agenda or something? Yes. Okay. This is important so that those who receive the notice can decide whether they want to attend or not. Okay. You know, and if there's any special resolution to be proposed, the notice must contain the terms of those special resolutions. Then the notice must also contain a statement that any member who is entitled to attend and vote can nominate and appoint a proxy. Proxy means somebody to represent me. Okay. To attend and vote in his place. This is important. Okay. You know, because members may not, for some reasons, be able to attend, but they can send somebody as a representative to go and attend for me. Okay. Those persons must be recognized and given the same opportunity that the member ordinarily would have enjoyed. And that proxy need not be a member of the company, can be anybody. Okay. You know, I remember that when I was, when I just left secondary school, I just got into university then. I had to go and attend an AGM for my uncle then. Okay. And I was like, wow. You know, so people can attend by proxy, and the notice must tell them, remind them that they can do that. Okay. You know, now it is important that whoever is entitled to get a notice gets a notice, because but the proxy must be of age, isn't it? Yes, it can't be a minor. Yeah, it can't be a minor. Can't be anybody below 18. No, because there's a specific age limit. It can't be a minor. It can't be a person below 18. Okay. It should necessarily be somebody that is matured, that can see things and actually contribute to discussions, right? Okay. Now, I was saying that it's important that we observe this requirement for notice to every person that is entitled, because failure to send notice to somebody who is entitled can invalidate the whole proceedings. You know, the only reason why such failures will be excused if it is an accidental omission. Okay. Right? But accidental omission, whatever, however you see it or explain it, the law is clear about something. It is not enough for you to say, I didn't know that that was what the law was saying. Or, the articles, I didn't know that that was what it meant to. Otherwise, that will not be seen as accidental mistake. It will not be seen as accidental omission. Okay. So it is important that company secretaries and directors understand these things. In order for them not to so that have their meetings invalidated. Yeah. Exactly. Okay. Exactly. Okay. All right. So let's also go to the issue of disclosure of persons with multiple directorship. Yes. I do know that under 278 subsection 2, they specify that a director, you know. For directors, people who are proposed to be appointed directors of a public company. Okay. Yes. Again, we mentioned that in past editions. He cannot be a director in more than 5 companies. Yes, under the Company and Matters Act. You cannot hold directorship in public companies, in more than 5 public companies. Okay. Right? And where you are even proposed as a director, whether you have more than 5 or not, of a public company, you must disclose if you hold other directorship in public companies. You know, you should let the members know before they now say, okay, we still will know, but you can still do it. But even if they want to say no problem, you can still do it. You cannot be a director in more than 5 public companies. You know, again, because of the public interest nature of these entities, it is important, like we said in the last edition, that resources are brought to bear, you know, fully for the success of these enterprises. If you are going to be a director in a public company, it is important that you have the time to really give Okay. You know, the rescue, of course, it's expected that before you are even proposed, it's been determined that you have the value to bring, the requisite experience and exposure. But do you have that time?
Okay. Okay, I'm afraid we just have to leave it here. I know that we're supposed to even discuss the issue of auditors and those who are disqualified as editors, but I know that will be done subsequently. Right. Yes. Mr. Tolulokpe Adeola Shonaike, thank you very much indeed for your time.
You're welcome.
As always.
Adina. Thank you.
And that's where we call it quits on this week's edition of the program CAC Weekly. We do hope you enjoyed watching. Now, for comments and inquiries, please take advantage of our social media handles and our helplines. On Instagram and Facebook, it is Corporate Affairs Commission. Our email is at cservice@cac.gov.ng. You could also reach us via our website at www.cac.gov.ng. And our helplines are on the numbers 081-822-99016 or 081-822-98971, 090-874-01598 or 090-874-01599 and 090-874-01600. To join us next week for another interesting edition of the program CAC Weekly. Same time and same station. From me, Amina Jabril, and the whole team here, it is bye for now.